next day. This was a case that your lordships required to give anticipatory bail. Because of the facts of this case, because of the series of judgments, my lord, which I have held, anticipatory bail can be granted in POCSO cases and this kind of cases. Your lordships would not be able to undo the injustice done to me. I will never be able to get my liberty back. And this is something the law provides to me. I need to be heard. So, my lord, today, as I said, I understand it's a vacation court. Unfortunately, this FIR was registered in the vacations. Otherwise, I would have gone before the regular court. I would have had 1.5 hours, my lord, to take the complaint apart piece by piece. But today, my lord, what I have done, I have only spoken in the air. I have not shown your lordships the complaint. I have not shown the evidence. Give me, my lord, half an hour before your lordships rise today. I will show your lordships the complaint. I will show evidence, my lord, one sealed cover after another in relation to each of the incidents for the limited purpose of satisfying your lordships today that this matter needs your lordships attention tomorrow, my lord, Saturday, Sunday, Monday, any day your lordships put. I am going to come back before your lordships and satisfy your lordships. But till that, I can't be arrested.
Yes, PP, I would like to ask you a question. Is it true that the first FIR registered, the sections under which the FIR has been registered, sections of offences,
whatever
they are all below 5 years of.
My humble submission.
And later on, you have improved. Is it so? If that is the case,
I'm sorry, some of the material paper placed along with the anticipatory bail petition. Kindly see charge sheet page number 24.
Charge sheet is filed.
Yeah, earlier case, what my land friend submitted before
the
this
earlier.
Page number 24.
24.
Your lordship's question, I am repeating, answer is yes. Every offence was below 5 years.
20 page number 24, lordship got it.
Yes.
11, serial number 11. After that, CCL Chintala Abi, daughter of Vilas, age 15 years. That is the seems to be my land friend submitted argument.
Yes.
This seems to be filed the 2021 crime FIR, Nirmal Town same was registered. Subsequently, final report filed. Whether it is I need to verify. This is the charge sheet filed by the.
All right, that is one aspect of
Yes.
the matter.
Yes.
The other one is the FIR. All of us know that the first information report has to be taken into consideration. In this FIR, the sections mentioned, they prescribe only 5 years or less than 7 years of punishment.
Initially, at the time of registering the crime, the subsequently same was altered. I filed the 5 and 6 I read with
may give the section numbers and offence, my lord. Lordships may just note.
Also was only to move the criminal or set the criminal law into motion. Subsequently, the very next day, a 161 statement was recorded. There was a complaint. There seems to have been some collusion. They have not recorded the final details and all that. Next day, because of the uproar and the hue and cry made by the NGOs and other organizations, the Chief Minister has taken special interest in this and formed the SIT. The SIT habeas officers come the other day and recorded the entire narration of the girl. The girl cried and told what all had happened. No doubt there was some relationship between them, but that does not mean that that boy can, sleep over her. And then all the ingredients to constitute the offence under section 511 have been made out.
No, madam.
That's fine. Let me. Yes,
so there is nothing like second FIR or anything. It is the first FIR which has been altered the very next day.
Victim mother came to the PS on 8/5/2026 on 10 o'clock. After receiving the complaint,
is it a written complaint?
Yes, madam.
Yes,
madam.
Yes.
Written complaint. Immediately registered the case. Subsequently, after taken into the statement from the victim, case was altered.
Specific to my lord's question, the FIR was given on 8th May. Complaint. 8th May, my lord, 4 sections were applied. Section 74, Section 75 of BNS, which is my lord old 354 and 354A. Punishment is 5 years, my lord, for Section 74, and 75, my lord, punishment is 3 years. 2 sections of POCSO were added, Section 11 and Section 12. Section 12 is the punishment section, punishment of 3 years. And I'll show to your lordships. Lord, my learned friend tried to, my lord, in some manner say that there is nothing that happened. Some negligence was there in registering the section. If I am able to show to your lordships the complaint, every aspect of the complaint taken to be true, given by the mother 4.5 years, and your lordships will see fully legally advised. The language, my lord, I also was surprised, but I must credit that eventually, my lord, they did a good job, good for them. Fully legally advised. And they say in March they took legal advice, they wanted to initiate legal action. So that complaint, but today if it can be that in a given complaint, a different section arises. But section 5 was arising. The police by mistake did not include section 5. I will not have a case saying that police did not include 5 earlier. Therefore, my lord, I should not be today accused of an offence under 5. Complaint, everything taken to be true, 5 not made out. So what they do, they come back with a statement next day, alteration filed on 11th. And my lord, your lordships have held in POXO cases, even 1 day's delay in certain circumstances can be fatal.
No, they said the statement was recorded on the very next day.
9th.
No, my lord.
9th.
Alteration filed on, I agree, my lord. But I'm saying between 8th and 9th, my lord, because 8th they did this, 9th they say statement. My lord, I am told there were 2 statements. At this point of time, my lord, I'm not in a position. One was by the original police paid Bashirabad, my lord, then an SIT was constituted. I think SIT also visited. I don't know which statement they are referring to. But let me take it that the statement is of 9th. 8th, my lord, 8th May, incident is of 1st January. March, they say they took legal advice. They wanted to initiate legal steps in March. So May when they file, and when your lordships looks at the language, my lord, this is not one of those, FIR is not an encyclopedia. My lord, some of those cases, FIR is only giving information. Police then, my lord, conduct investigation, come to conclusion. This is a case where FIR itself, my lord, is extremely detailed, legally advised, refers to Supreme Court judgments, indicates what are the cases of harassment. So a case of harassment filed. My lord, no, my lord, graver offences filed against me. They wake up the next day and my lord, they give the complaint, they say the statement is given. So therefore, I am submitting. And my lord, I am supported by Supreme Court judgments which say that there is an embellishment. The words your lordships are used as any embellishment, any ornamentalization, any improvement to complaint. My lord, your lordships will take it with a great deal of suspicion. All that I am saying is today, as your lordships hear the matter, this is a matter, my lord, that may require the consideration of an anticipatory bail. My anticipatory bail cannot become infructuous whenever your lordships hear the matter. But if your lordships want me to discharge a slightly greater burden, I can take your lordships through the complaint, show to your ladyship, my lord, from the complaint how no grave offence is made out, how from the complaint there's a...
No, even on this interim protection petition, I don't want to take a decision without hearing the victim's side. Okay, so if you are ready to advance your argument
Yes.
tomorrow, I'll post it tomorrow so that he can come to it. On that interim, you want 1 week's time.
No, my lord, 1 week, then the police will arrest me, my lord. I want to join the investigation. I want to go today.
All a bullshit story. I'm sorry to say that.
This is not a
Please
language we
don't
use in
use
the
such
court. I'm
language.
sorry, my lord. We must maintain the decorum.
I'm extremely
Nobody
sorry.
supports any incident of this sort,
My lord, once
but using such
I
language is not.
would take back my words. I would say it's a cock and bull story. It is not right what they are saying. My lord, one submission. For a minute, your lordship may kindly see the complaint which has generated from me. Paragraph number 6 of the complaint, page 17. For a minute.
No, I'm asking you
My
if
lord.
you will be ready to argue on the interim application that he's asking, even before the anticipatory bail is
What I respectfully
considered.
submit is, my lord,
So if-
even an application of opposing for simple reasons. The father of the boy is the Union Minister for Home Affairs.
My lord,
Just sir, please sir, if you have not concluded, just if you finish, then I'll argue. I don't want interruption in between.
You may continue. Yes.
I think.
All right,
I can take a
his
seat.
father is a minister, so
Well, the father is a minister of state. And then my lord, your lordship will be surprised. On the evening at 6 o'clock, I go to the police state, Bashirabad, to lodge the complaint. Till about 10:30, don't register the case. They pass on the information to you. And they wanted to show that there is a counterblast to this case. They go to Karimnagar and lodge a complaint of some extortion, saying that 55 lakhs they are demanding, just to show that it's a counterblast to this case. So how influential are they, my lord? And what is
now
that
what is this
influence?
girl doing?
She
No,
is a student, my lord.
so what about her birth
I
details?
really do
date
not
of
know
birth?
my final details.
So
of
get
that.
the
That is why
details
I'm
by
only-
tomorrow. The police can do the verification.
My lord, I should be given
Why
some
there are,
time
he has
to file
filed
the counter.
two
My lord,
date of birth certificates.
My lord.
One is of 2008 and one is of 2010.
My lord, even
So
assuming
how can
either
that be?
2008
Two two
Even
date of
in
birth.
2008 is correct or 2010 is correct, she is a minor below 16 years of age.
No, but then there is a charge sheet which said she was 15
No,
years and
correct.
2021.
Determination
So all
of
these
age.
things, the police
Well,
can do the
determination of age
verification
as
and
per
come
Supreme
tomorrow.
Court, the law laid
Yes,
down
ma'am.
is.
Yes, ma'am.
I have already heard you, sir, with regard to your interim application.
My
You
lord,
are
Only-
opposing it. I have heard you
my lord,
also
your
with regard to
lordship
the
may kindly
interim
grant me
application.
some time to file the
Yes,
counter.
yes, anticipatory
And I do not
bail.
have much material. And let them file those 161 statements and 161 statements. Or let the public prosecutor serve us.
I'll pass orders on this interim application tomorrow and the anticipatory bail will take up next week. Okay? Only on this interim application, whether any interest protection is
My
to be
lord, your
given or
lordship
not, I'll
may
pass.
kindly see the contents of the complaint for a minute at least. What my learned
I'm not allowing it,
No,
sir.
no, but you're saying your lordships are going to pass orders.
Orders on this IA 1 of 26. He says there should be interim protection even
So
before
what
the
my lord,
anticipatory.
Your lordship asked him only
So-
one question. One question. How is it that you are special from others as far as?
So do you think I will not be considering it while passing orders in IA 1 of 26? I have to dispose of this IA 1 of 26.
My lord, then
Either-
everybody, why are all others are not?
So
entitled
why are
to
you
interim-
presuming that I have allowed it?
No, I'm not saying
Then
that.
I am going to pass orders
I'm
tomorrow
only
on
saying-
IA 1 of 26.
May,
Now,
Okay.
how is it that his application is separate from all other applications?
All right, that's
And
what
the
I have asked and
convention-
he has answered. You also
convention-
submit your.
The convention of this honorable court, your lordships are very well aware of. Any application which is coming for the first time, fresh matter, is automatically go for 1 week. And that too, now what is the urgency? Now he is absconding. He's not in jail. It's not that he's in illegal custody. What is the urgency? And why is it that I'm being forced to argue only tomorrow itself, even without going into the
I'm not
material?
forcing you to argue
No,
that
but my
bail
respective
petition
submission is, my
tomorrow.
lord, your lordship may kindly grant me some time.
So you want time even in IA 1 of 26 also?
That is not different from the main application. That is what I'm saying.
All right, I'll
then,
consider that.
my lord, may I make one? Because my friend didn't want me to interrupt him and he was right in saying, so I thought it's better that I keep my arguments till he finishes, so I reply. My lord, first submission in relation to what my learned friend argued. My lord, your lordships have not heard me in relation to this being a counter blast case. I have not referred to any fact. I simply said, even if the complaint as filed by the, my lord, my learned friend will now give me the same
If you are
custody.
both-
I'm sorry.
If you are both going,
Yes.
no, see.
But he must have the same rules that he wants to set for others, my lord. Once he said, please don't interrupt, my lord, I kept quiet. I said he was right. He was right in telling me. He was correct in correcting me. I corrected myself. Now let my learned friend not, my lord, make a mistake that I had made earlier. First, I had not referred to, my lord, this being a counter blast case. I understand that when I argue anticipatory bail, I will have to argue my case at a greater detail. For the purpose of interim protection, today, my lord, I said, I will assume everything said against me, which is, my lord, in the complaint filed by them on 8th May. And I, my lord, also said I will take the burden of, if necessary, showing to your lordships the entire complaint, and from that complaint, no graver offense than punishable more than 3 years is made out. Only sexual harassment case is made out, which is 3 years. 8th May, your lordships asked a specific question to the learned public prosecutor. Did the complaint as filed originally have offences below 7 years? But the learned public prosecutor fairly could not contradict it, though he did not admit it, because he understands this is a sensitive case. Everybody wants to be sensitive about this. But second submission, that I take serious objection to my friend stating, my lord, and saying that we are trying to be special and there is a convention in this particular court. My lord, I would respectfully bring to your lordship's notice. I started my argument saying that there is no bar for grant of anticipatory bail in law. There are Supreme Court judgments which say that if the court has the power to grant anticipatory bail, it has an inherent power to grant an interim protection. Third argument I made, this honorable court has concurrent jurisdiction to entertain an anticipatory bail. So I placed it, my lord, on the ground of law and the Supreme Court judgments. I did not place it on any special right that I claim. I in fact said, my lord, I am no special. If I am special in something, unlike any other person who is accused, my lord, they will not be vilified in social media and posters will not be put up all over the city. My posters are put up all over the city. I am vilified. I am made a villain everywhere, and political parties carry out rallies against me. Have your lordship seen this happen with any other accused? That is where I am special. I am special where I will be victimized. I will be punished even before your lordships render justice to me. I did not come and make a complaint because of all these things. I need protection from the court. I understood that is a part of my fate. My father may be in politics. some things are good, some things are bad. This is a bad thing that will happen to me because my father is popular leader. He is someone who is popular in politically. I did not make that particular case. So for my friend to refer to my father and try to say that, my lord, I am trying to use any political influence was wrong in the context of the limited argument we are making before your lordships today. But I come back to this one request. I am ready to show the complaint, my lord, in the next 15 minutes. I will show this evidence one by one and I will assist your lordships. Now I am arguing, my lord, from an interest of justice perspective. One, I do not want the anticipatory bail to become infructuous, number one. Number two, I don't want, my lord, the investigation to suffer. I want to join the investigation today. I am requesting your lordships, grant me limited protection. I will go, I will appear before the police. I will give them this material. The police will understand all of this. The police will know whether they would want to arrest me or not. Merely because offence is above 7 years, your lordships have clarified in Supreme Court. Arrest is not mandatory. 41A old. My lord, is only if the police feels, my lord, that below 7 years, my lord, if they want to arrest, they will follow a procedure. Does not mean if it is more than 7 years, it automatically, my lord, has to be arrested also. I am sure that, my lord, if my learned friend at that particular, my lord, he had been a public prosecutor at one point of time, if the police come to him with this evidence, if he was an objective public prosecutor, and I'm not putting the burden on him, he would have. ACB standing also. I'm sorry. But my respectful submission is, I really want to assist the process of law. And, my lord, I do not want. I'm only saying, my lord, I'm ready to argue my anticipatory bail today, which I cannot insist because I realize I am not special, though my friend may think I am not. I understand the victim will have to be heard and the victim may have to be given reasonable time, and, my lord, I fully recognize that. All that I'm saying is, by your lordships of protecting one victim, let me not become a victim in the process. I need protection from this.
I'll consider and pass orders, either accepting your request or rejecting your request tomorrow. In IA 1 of 26, I'll pass order, and a bail application will be decided after a week. So I'll post it next week.
May just
tomorrow it will be.
May then just
yes, is relying only on a limited material which is available at the preliminary stage. Subsequently, the lot of water has gone under the bridge. So where is that material? Let at least the public prosecutor supply us with the material. Today there was a 161 statement recorded by the magistrate. It's going on. And the 161 statement of the SIT in charge IPS officer has been recorded. Where is that? That will reveal the real truth. And what my learned friend is saying that our influence on the complaint is incorrect.
It is, my lord.
All right, sir. I think both of you are repeating yourself again and again. I know your anxiety, but don't pass it on to me. I will not be.
Very well, ma'am.
Yes,
okay.
But,
it will be taken.
May just only for the purpose. I am not arguing anymore. But there are 3 Supreme Court judgments where an interim protection granted. My lord, Supreme Court sustained it. I'm just giving those 3 judgments. I'll give copies to
I
my
have
friends.
more than dozen judgments rejecting the POSCO cases, remanding the matter to the trial court.
There are cases both ways.
Taken.
There are cases both ways. There is no.
May-
There are no.
circumstances are
No,
altogether
1 minute.
different,
Yes.
my lord.
Each case has to be considered.
On a criminal set for more than 30 years. My respectful submission is those judgments what my learned friends are referring to are the different situation altogether.
Every
They are
case.
altogether a different situation.
Every case will
Not
be.
such graver offences, my
Sir,
lord.
if you are going on.
I'm sorry.
with this-
I'm sorry. I'm sorry.
Every case is distinct, and the facts of each case will have to be looked into.
Very well.
The judgments which he refers to will also be looked into on the touchstone of this case, facts of this case. So rest assured that all the factors will be considered and passed orders.
But all the 3 cases that I'm giving to your ladyship are under POXO. One of them is under section 6, which is the same section, which is later sought to be improved, not originally put. Yes, my lord. I'm giving, my lord. So all the 3 judgments, my lord, that I'm relying on are granted interim protection by the High Court, maintained by the Supreme Court in POXO cases only. And my lord, there are at least 7 or 8 High Court I'm not placing.
All right. So tomorrow. Yes, call the next case.
My lord, your lordships have concluded the arguments, or your lordships.
In IA 1 of 26, your arguments have been concluded. You want to advance any further arguments in IA 1 of 26?
Yes, my lord. I'm not at
All
all
right,
prepared.
then
I
I'll
don't
hear.
even know anything.
All
Lordship may kindly permit me to argue the matter tomorrow morning at 10 with regard to this interim application.
Interim
of my
application.
learned
All
friend is
right. I'll
seeking
hear
for.
him also and pass orders tomorrow.
And your lordships would grant me also, my lord, because I.
Yes,
if my
yes. You
learned
want to
friend wants-
appear in person or virtual, you can do it. Yes.
But, because of the pressure of your lordship's board, Can it be higher up on the board, my lord? Because as I said, we want to go and join investigation as early as possible. Anyway, it's a bail matter, it generally comes higher up only.
Every second criminal will come and say that he wants to join investigation.
But I take very strong objection, my lord. My learned friend is a counsel. He cannot categorize anybody as a criminal. I'm sorry. He appears for several persons who are
whoever
accused.
may be, please.
Graver offences.
No, please.
I'm sorry, I had a.
Whoever, no, please. Mr. Please.
Sorry, ma'am.
None of you will raise your voices
Yes.
in this court.
I am-
If you are, want to, do it, then I'll recuse this
No,
one
no,
case. Let it be posted before another bench.
No, I'm sorry.
No problem.
The only thing is.
No, you have to maintain the decorum of the
My
court.
lords are right.
You
But-
can't raise your voices,
No.
and one of the principle is a person accused, that's the reason why we call them accused. He is
Correct.
only accused of a charge. Unless proven guilty, he is presumed to be innocent. So you can't say that, so-and-so is so-and-so. Please,
No.
restrain yourself, you yourself are a public prosecutor or prosecutor.
a public
Not a
prosecutor,
public
I'm
prosecutor,
sorry.
maybe ACB counsel or whatever. So all of you are senior counsel, you know the law, you know the principles. Don't get, personal
Correct.
with anything, any case.
Anticipatory bail, my lord, it is so. I don't
No,
know.
see, we should not
Very
get attached with,
mysterious.
your client. You are a counsel, that's it. Please be a counsel.
Very well.
Yes.
Deeply grateful.